All right. Good afternoon, everybody. Good morning, those of you joining from the West Coast. Thanks for joining us today for one of our webinars. We're delighted today to have Phyllis Marcus here from across the street at the National Advertising Division. Phyllis is the new head of the NAD. She's been there since April 1st. And we're going to talk today about the National Advertising Division. We'll start with an overview of how NAD operates. We've got a wide range of people, some folks who've been doing NAD work for a long time, some folks who are new. So we'll do a sort of a level set with some basics about NAD, and then we'll talk about sort of the process as it, the various steps in the process, sort of walk you through a case. And then we'll have a Q&A with Phyllis to talk about changes and developments there. If you have a question, use the Q&A to pose your question. We'll answer it if we can. If not, we may respond afterwards. And thanks again to Phyllis, and thanks to all of you for coming. Okay, so we covered. So what is the National Advertising Division? It's part of the Better Business Bureau national programs. It's over 50 years old. It was started in 1971. The advertising industry recognized that perhaps there were concerns about the accuracy and potential deceptive nature of advertising. So the industry did what responsible businesses do. They tried to fix the problem. And one of the ways they did that was by creating what was then called the Advertising Self-Regulatory Council. And the cornerstone of that really is the NAD, the National Advertising Division, which is a tool to monitor and resolve national advertising disputes, enforces standards of truth and accuracy, and resolves disputes to, again, support consumer trust, support fair competition, and efficiently resolve issues with advertising and potentially keep little problems from becoming big problems as things creep. NAD gets its cases in really two ways. Competitors challenge those competitors' claims. NAD also does its own monitoring and covering a wide variety of industries and issues, looking for things that they think are important and worthy of its attention to try and, in some ways, stop incipient conduct, but also to guide the industry on how NAD views certain types of claims, the type of substantiation that might be necessary for those claims, and guide industry. It is meant to be an aid to companies who want to do things the right way, and the monitoring cases actually perform that function at a really efficient manner. The NAD decisions are available, and they're a great resource for lawyers or business people who are trying to decide where the lines are on advertising. I mean, they deal with these issues every day, and there's a really rich body of case law. We've got a link in the slides to the online archive to help guide you.
And just to jump in, if anybody has a question when you're looking at an advertising claim, what does it mean? What's the substantiation standard for, let's say, a doctor recommended claim or something like that? I can guarantee you'll probably find the answer in the BBB National Program's online archive of cases. So whenever a client asks us a question, that's really the place we go to. We look at courts, obviously, but also the NAD, just simply because there's so many decisions. That's such a big and great library.
Now, I will jump in here so as not to falsely advertise the online archive. It does contain our whole body of jurisprudence going all the way back, but it is available by subscription only. And so I would encourage those of you who don't have a subscription to consider getting one. All of our press releases are available to the public, and they give you a high-level summary of the cases. If you are a government representative or an academic, you can access the online archive for free, but otherwise you have to pay a small fee.
Look at Phyllis already teaching us things here too, but we amenable for our clients is we do have an access to that, and we will help you out and find that answer there.
So the majority of cases at the NAD do stem from competitor challenges. It's a different process than litigation. there's no document discovery. There are no depositions. You can't bring counterclaims. You do see competitors challenging each other's claims frequently, but that is done in separate challenges that are resolved separately. We have a link to the NAD procedures if you have questions. It's pretty clearly spelled out how everything works there. Again, we'll keep touting the body of case law because it really is, especially on claim substantiation, how to substantiate a claim. What's a reasonable basis for a claim? What's not a reasonable basis for the claim? And it's important to note that at an NAD proceeding, it's the advertiser that has the burden to show that there is a reasonable basis for the claim. It's not like a Lanham Act claim where the plaintiff has to prove the falsity of the claim, or even an FTC investigation. It's more similar to an FTC investigation where the FTC has a body of case law that an advertiser must have a reasonable basis for their claim. And many FTC advertising investigations focus on whether that advertiser has that reasonable basis. The same is true with the NAD. The focus in most instances is on whether there's a reasonable basis for the advertiser to be making that claim. And sometimes that's very scientific. Sometimes it's based on survey evidence. Sometimes it's based on science. Sometimes it's just based on sort of basic business practices or documents. But the reasonable basis for the claim is really when you look at those decisions, that's what's being discussed.
And I'll jump in again.
Yes, please
if
do.
That's okay. We really do operate in a way, not like a true trial court,
Right.
but because we have our decisions and those decisions are precedential within our organization, it's different than what you see in the enforcement sector. So when you want to understand what the Federal Trade Commission is doing, for example, you would look at the complaints to determine the allegations and to get a sense of what the Federal Trade Commission would deem to be false or misleading or deceptive. And you would look at the orders, that is the way the case has been resolved, to determine what remedies the Federal Trade Commission has deemed appropriate in that case. But you don't see the agency's analysis. That is different than when you come to the NAD, because in addition to an outcome, that is whether the advertiser can or cannot substantiate their claims, or whether some modifications might be warranted, you actually see the National Advertising Division staff's analysis and thought and citation to prior cases so that you get a better sense of the why and not just the what.
That's a really good point. I want to build off that, Phyllis, because I hadn't really thought about that. But when we have clients a lot of times who are interested in making a claim or engaging in a certain type of marketing campaign, they'll say, okay, well, give us an example of when you can't do it. And a lot of times we'll say, okay, well, here's the FTC case. And the FTC, of course, they do have the complaints, they do have the settlements, and those are helpful. But a lot of times, because there isn't as much detail and analysis, a lot of times clients will say, well, that's not us, we're doing this differently. And I think that with the NAD decisions, that is a lot more helpful because it goes through like, okay, we look at the context, and context is key. And it's not just the statements, but they're shown in this imagery, and then that's the reasonable net impression. So I agree. I think that does make it a lot more helpful for us as counselors and attorneys to say, we can look and give you a little bit better idea of how the NAD would look at this. And we have more information on analyzing it as opposed to 1, 2, 3, 4, 1, 2, 3, 4.
Right.
Okay, so I think that's a really great point.
And when the NAD issues its decision, it makes recommendations to the advertiser. It not only says that there's not a reasonable basis or there is a reasonable basis, but if they find the reasonable basis is lacking, they discuss how claims need to be modified, which also helps the advertiser that's subject to the decision, but also the industry more broadly to understand where the lines are, where the fault lines are, and what's safe and what might be a little bit more risky. Again, we've talked about the president. The staff at NAD has been doing it for a long time. Phyllis spent in her youth some time at the FTC.
That's right.
She just mentioned to us that another FTC veteran, Mike Ostheimer, is joining her staff. So there's historically been a lot of people from the FTC who have ended up at NAD, and I think that helps provide, people who know advertising law, and also gives the agency, the NAD, even enhanced credibility because they've got people who've been on the front lines enforcing deceptive advertising cases. There's no size threshold. It does have to be national advertising, but that's a pretty easy threshold to satisfy, especially the way advertising is done today. And it's across many industries. They don't. At times, it seems like they've got a specialty in telecom when you've got all the cases there, but it's across all types of industries, and the principles are the same. The products change. So we mentioned a little bit about the FTC. I mean, the FTC has historically been a big proponent of self-regulation. It, in some ways, takes some work off the FTC's plate for companies who want to do things the right way. Concerns about claims they might be making or substantiation that they may or may not have can get resolved through the NAD process and allow the FTC to focus on other things with some confidence that the NAD is doing its job, in resolving cases. Sometimes the FTC will see something's going on with the NAD and decide that they may need to get involved because of the nature, especially if they think there's a lot of consumer harm. But the FTC historically supports the NAD, and if the NAD will make its recommendations. If the advertiser says it's not going to follow those recommendations, or it becomes pretty apparent that the advertiser is not following those recommendations, the NAD will refer that matter to the FTC. The old line used to be those referrals went to the top of the pile of things that the FTC is looking at.
And I can confirm that.
Yep.
There was a period of time where those referrals came directly to me.
Yep.
And we gave them quite a bit of attention. And most times, the advertiser who may have been reluctant or recalcitrant decided to re-engage with the NAD. So it was an extra nudge on the part of the enforcement agency to support the self-regulatory process and have the advertiser come back to the table.
Yeah, and we've had circumstances where, we went through the NAD process, we went to the FTC, and we sort of were able to work a path forward that everybody could live with. Sometimes, another round of discussions helped move things forward. Or you have clients who go and talk to the FTC and realize that that recommendation that the NAD made is something the agency takes seriously, and sometimes clients then are a little bit more willing to change their behavior because it's not just a recommendation from the NAD, but there's some threat or some force behind the threat of FTC action if they don't change things.
We also not as often, but and referrals are not common.
Right.
I will say. We are self-regulation kind of at its best, and most parties to our procedures comply ultimately. But we don't just refer to the FTC. We can refer over to the Food and Drug Administration and to some of the other enforcement agencies as well. And it's not just the NAD at the broader umbrella organization, BPB National Programs, that sends cases over, but some of our other self-regulatory cases outside of the national advertising sphere also end up at the regulator.
Yep. And there was a case last year where the New York Attorney General sort of followed up on an NAD recommendation to JBS on environmental greenwashing claims.
Our action was cited in the New York Attorney General's complaint.
Yeah. So it wasn't a direct referral, but the New York Attorney General felt apparently that JBS wasn't doing what it promised NAD it would do, so it decided to take action. All right, can we go to the next slide? So we've talked about FDA, FTC, FCC, and the FTC obviously has options as to what it does, but often it uses its bully pulpit to try and enforce the NAD's recommendation.
Even our smiling bully pulpit.
In smiling bully pulpit. And every once in a while, the cases go to litigation because the advertiser thinks that they're just wrong, and that's certainly their right. The BBB, NAD, has also recognized where a lot of advertising comes today, and social media. So it has reached out to Meta and to Google to form partnerships with them to try and strengthen truth in advertising. Do you want to talk a little bit how that works?
Yeah, these are formal referral partnerships. We have a couple of informal ones as well, but the formal ones are with Meta and with Google. And once we have issued a decision that involves, at least in some part, social media advertising on that particular platform, we send the decision over through a reporting channel. And it is accepted on the platform side and compared to their advertising guidelines. And if our decision indicates a violation of the platform's advertising guidelines, they can take that decision, they can take quicker action on the underlying advertising and pull it down. So it's a faster way to get some of our compliance accomplished.
And that's working. You see results?
We see results.
Okay, great.
It's almost like you go straight to the heart, as
Yeah.
it were. You don't have to wait for the advertiser to go contact somebody and then they contact somebody. Seems like a lot
Yeah,
of
it's an
fast.
efficient,
It's
it's
very
efficient on the back
efficient.
end.
Yeah,
Yeah.
so I think that's something that's a lot more effective that would really, a lot more companies should be considering when they're seeing things on social media and on Google, that the NAD is a good, viable, efficient source, because I know that that's often what it is. If your competitor is doing something wrong, you don't want to wait forever to have them fix it. So this is a great opportunity for them to do that quickly.
It's sometimes challenging. There's a lot going on with the platforms. This is a great way to get their attention.
Right.
Right.
And Shahin's going to walk us through a challenge.
Yes, and Phyllis, you'll jump in here. We'll give us
As I have.
yes, absolutely. Give us some tips. I know we've done a lot of these, and I apologize in advance because I know some people on the call have already done this and they know this, but I would really like to walk through this because there are some details here that not everybody knows. So I encourage you to listen, even if you've been through this before. Nowadays, there are three tracks for an NAD challenge. The Swift track, which has two sort of types of that, the standard track, which is really what has been the track for many years, and then the complex track. And I'll start with the standard track. The standard track, you have the challenger that opens they'll send a letter to NAD. We'll talk about what that looks like. And then NAD will decide whether to open an inquiry, and from there, send that letter to the advertiser. And then there's typically 2 rounds of briefings, and there's a letter. The advertiser has the opportunity to send evidence in. This isn't a court where you don't take depositions. You can't force somebody, motion to compel documents. It's you provide the documents as the advertiser that you believe support the claim. And then you have 2 rounds of briefing. Each party meets with the NAD staff attorneys and management in some instances. And those are ex parte. It's not as though we all go to court and we're all sitting in court together, cross-examining each other. You meet with NAD. NAD has a chance to ask questions. You have the chance to speak with them. You can see the filing fees here. Filing fees depend on the revenue of the company. And in the standard track, there's one round, and then you have a final meeting, and your decision is issued after that final decision.
Phyllis, can you give us a rough pie chart on how many are Swift, how many are standard, how many are complex?
So those insiders on the call, if you're reading our annual reports carefully, you will see that the Swift track has grown as a piece of the pie since we introduced it probably 4 years ago. And it is a very popular option, both to get a decision quicker and to cabin the issues to a very small chunk. And so people really have found the Swift track to be appealing. The complex is the least frequently used of the 3 tracks because it is just that, deep substantiation, multiple products, multiple issues. It doesn't look more like litigation, but it takes longer than the standard and swift tracks. And the parties have a bit more control over the timing in the complex track than they do over the standard or the swift tracks. And Swift really was designed to get kind of time to decision, which is how you've termed it here on the chart, to reduce time to decision and to get that easy to analyze advertising down faster if that's what the outcome is determined to be by the NAD.
And speaking from experience, the Swift track it's just so effective and efficient.
Right.
It's one of those things where you send a letter, NAD opens that, they'll open it, they'll decide if it is appropriate, right? Because the idea of Swift, right, Phyllis, is that it is something that's a well-defined issue. It's not something where you're gonna have to go look at a bunch of science, a bunch of documents and that type of thing. It's something that's pretty clearly, it's oftentimes an express claim, or if it is an implied claim, it's very easily understood to be an implied claim. Well-defined issue, not a lot of evidence to look at. And then you can really get, Len, I know we've had cases where it's, there was an ad that comes up. It was a TV ad. Somebody got very angry. Our client got angry. We sent a letter, got the Swift stand, and it was down within, gosh, like few weeks. It was very, very fast. So I encourage companies that if you are looking at something that is one ad, one claim that's really detrimental to your company, to look at that Swift track. The disclosure track, let's talk a little bit about that if you don't mind.
It's used a little bit less than I
Mhm.
think we anticipated. Well, let me say this. Swift has expanded in terms of its uses. And so the disclosure track, it really, if you could think about the absence of a disclosure in an influencer post.
That's what I was thinking.
That would be the archetypal Swift disclosure track filing. And we don't see as many of those as Swift standard cases. Now, following up on what you said, there are times when a challenger may choose a particular track, and we take a little bit of time, not too long, to determine the appropriateness for the particular track. Some things get moved from Swift to standard, and sometimes cases get moved from standard to complex.
Mm-hmm.
And so, don't be surprised if you happen to fall into one of those buckets with one of your filings.
And I know that's happened to us. And you have a chance to talk. I think
Right.
The one thing I like about NAD too is it's not one of those things where it's like a black box where we send a letter and then you send a letter back to us and we're like, wait, where's this come from? Your staff attorneys are pretty communicative. They say, hey, look, we saw that you sent this in Swift. We think that this probably we'll evaluate it, but you should consider putting this into standard track and doing it that way. Can you give us a little bit of insider information? I know we're going to go a little bit more. We're going to have some more Q&A. When we're looking at these types of things, what are things that we should think about when, I have a standard track case. I want to bring a lot of different types of claims. I wanted to go after the influencer marketing. What should I do if I want to stay in standard versus complex? Is there anything, and you don't have to answer this because I think this might be very, very case specific, but are there things that we should be thinking about if we want to keep it in standard versus moving it to complex? Or is it just really just cabin the issues?
Well, I would say cabin the issues.
Mhm.
And we've had some thought, we have given some thought to whether we should draw a hard line around the number of claims that can be challenged and still remain in standard. Some of our sister agencies around the world have hard and fast rules relating to the number of claims they will consider. And so we have floated that. We haven't come to a conclusion yet. There was it was not necessarily so popular by the participants in the system. But, we want to make sure that we are as efficient as possible, and these tracks help us to do that. So again, we will be really applying a critical eye to which track is which. Now, some of this is litigation strategy And so, you know your special sauce and where you would like to end up. But with respect to Swift, again, given the popularity of that track, we have one NAD attorney member who is kind of in charge of the program and shepherding it through. That's Eric Eunice.
Mhm.
And he has really stepped up to be masterful in this area. So I don't know what the end of this year will bring, whether we'll see an ever increasing use of Swift based on our whole pie
Right.
or not. But we built something that people wanted.
I'm a huge fan of it, I have to say, especially when people have limited legal spend. It just makes sense. It's not going to take as much attorney's fees to go through back and forth and briefing. It's just I'm a huge fan of this one. I was really happy when that was announced a few years ago. So how do you file a challenge? We'll get into the nitty gritty here. You can file a challenge online through the BBB portal. So back in the day, you would write a letter and then you would send the letter to NAD, and then NAD would send the letter and an opening letter to
Manual.
Yeah, it was manual. I mean, it was
Right.
Look, everything changes, right?
Right.
And then there was a portal that was begun a few years back that was you could go in, all of the documents would be on the portal. You could actually go online and do the challenge. And now they was it Monday? You just issued a new portal. So I'm excited. I'm using it now. And it allows you to choose which challenge you want to do. You click on the challenge and you upload the documents to the relevant case. And it makes it very easy. It's user friendly. It's like it's all in one place, right? So it's not, you don't have to search your email or search your L drive or your whatever your document management system is for everything. It's all in one place through the login. So
yeah, and if you are an attorney bringing multiple cases and you have a single login, all of your challenges should appear in one place. In your wow,
do.
you're
They
our
do.
wonderful
Yes.
test example. I'm glad. And it's easier for the NAD attorneys on the back end. We too had a manual process, believe it or not, and we have eliminated that. So we're moving towards greater efficiency for everybody in the ecosystem.
And a compliance challenge, we'll talk about a compliance challenge, but it's there too. If you want to do a compliance challenge, you can also do that. So I mean, it's almost like a one-stop shop. Anything you need to do with the NAD, it's going to be on the online portal. So for me, I don't, yeah. Talking about the filing an effective challenge. So this is just a screenshot of what it looks like. I think this is the new portal where you put your information in, you upload the documents. To me, it's very user friendly. You put the contact information in for your client and for the challenger. Oftentimes, if you've done a cease and desist letter before you file the NAD challenge, then you'll have the name of the attorney on the other side, whether it's in-house, outside counsel. And that makes it easier for you on your side to know who to direct the opening letter to and that type of thing. So it keeps things really streamlined. Again, that's the whole point, is keeping things streamlined and providing something that's not litigation. It's not going to take forever. It's going to take, the idea is to be more efficient there. After that, the NAD will send the advertiser an opening letter. And this is basically what the letter will look like. They'll explain who they are. And then they'll go through all of the claims that are being challenged there, and they'll ask you to confirm receipt, and there'll be a briefing schedule that is set up, that's set forth in the rules. We had a link to the rules earlier, but you can also negotiate the briefing schedule with the opposing side. I mean, within reason. I mean, because sometimes, like if it's the summer, if somebody's out of town or something, get an extra week, and then you go to the NAD and you just say, okay, well, we've negotiated, that extra week or whatever that might be. So there is some flexibility on that as well. Next steps. You will do the written briefing as we talked about. So the advertiser will respond to the challenge letter. They'll submit that evidence that they believe supports the claim. And then after that, the challenger has the opportunity to respond, the challenger's reply, and they can provide their own evidence saying, hey, we saw that study, but we have this other study, or we have this expert that reviewed the study, and here's information from our expert report saying why that study is incorrect. And then and then the advertiser has a final response, in which case that they can respond to that reply. We'll go on further, but one thing that I don't have here on the slide is that the challenger, and keep me honest again, the challenger can look at the advertiser's first response and say, we don't even need any more briefing.
Yes, and kind of cut the cycle.
Yep, cut the cycle. So in other words, if I'm the challenger and I'm challenging Len's advertising, I write the letter, Len sends some evidence back and he responds and I say, you know what? I think NAD can look at this right now and make a decision and let's just fast track it. And then from there, you go straight to the meeting, the meeting with the staff attorneys, where you talk and the NAD has the opportunity to ask the questions. You have the opportunity to present basically the evidence you've given already. There's no new evidence.
Correct. And
There's
no new evidence,
no new evidence.
Is permitted. We do have a procedure by which we can reopen the record to accept that evidence.
But for the most part, you go in and you're going to present the evidence that you've already seen, and maybe you'll be, criticizing the evidence the other side brought in. And then what I really like about the meetings is that, so NAD meets with everybody ex parte, and it's a
The challenger goes first.
Challenger goes first, and I love that. And the reason I love that is because then the challenger has the opportunity to say, "Hey, look, Phyllis, I think you should be asking these questions and these questions.
Right.
You already have your own questions." But then I say, "Okay, like these are the questions you should be asking." And then the advertiser, it's very fair, right? Because then the advertiser gets that we answer all the questions that you already had. Plus, you can say, "Hey, Len was in the meeting and Len had these questions. Like, what is your response to those questions?" So it becomes a very, I think, very fair process where there is an opportunity to get all of that information out there and all the questions both asked and answered.
Yeah.
And as you said, you can always, the NAD can do questions, you can do follow-up questions or reopen the record. There's a procedure for doing that.
Right.
And then after that, NAD goes back and I think you all talk among yourselves, you think about it, there's the secret sauce that I don't know, but and then a written decision is issued. It's provided to the advertiser first.
It's provided to the advertiser first, and the advertiser, you have on the screen, the advertiser has the opportunity to provide a written advertiser statement. Now, at the beginning of that advertiser statement, meaning literally the first sentence, we ask the advertiser to indicate whether they're going to comply, whether they're going to appeal, or whether they're going to decline altogether, just so everybody who's reading the decision understands the reaction and what might happen next. And we know what to expect next as well. And sometimes there's extra words thrown into the advertiser statement, and we have a page length or a paragraph length.
There's a limit.
And we don't like to see re-argument of the original case in there, within reason again.
Of course.
That's going to be my buzzword for today.
Within reason, absolutely. And then after that, there's the written decision will be published on that case library that you can have a subscription to, that we were talking about with all of the decisions, and a press release will be issued that you talked about. And that's public.
Right.
Anybody can see it. One of the things that's not on here too is that the NAD proceeding is confidential. So you're not supposed to, if I'm bringing a case against Len, I'm not allowed to go out and say, "Hey, Joe, I'm bringing this case against Len." That is all confidential. What Len sends back to me and what I send to Len, we agree is confidential, and that doesn't get publicized. That pendency of the proceeding is not publicized. That's within NAD's rules. And that's really important.
Right.
To keep that confidential.
It's a lot like we had similar standards at the Federal Trade Commission. We did not acknowledge non-public investigations unless and until such time as the disclosure was appropriate. And so here we do the two things that you highlighted. We have the written decision and we have a press release relating to that decision. And counsel actually isn't identified, and
I like that too.
It's just it's very just the facts.
Yep, absolutely. And then the press release is issued, and that is something that's public, and
Right.
it gets picked up sometimes by trade press, and we're gonna talk. I want to ask you a few questions about that press release when we get there, and I think we might be. And here's an example of a final decision. Here's an example of a press release. I want to make sure we get the chance to ask you the questions we want to ask you. Before we get there, I know people want to know the CLE code. The CLE code for everybody is NAD 2025. Again, NAD, National Advertising Division, 2025. So questions for you. We've got a bunch of them.
Okay.
So Len, do you want to start or shall I start?
Sure. Phyllis, you're new. Are you thinking what changes that we might see at NAD under your leadership?
So it's too soon to say,
Okay.
really. Big changes happened
Right.
before I came, right? So the SWIFT process, I think that was a huge change. Whatever we do with the input of our constituents and the practitioners before us and the companies that utilize our process. And so I expect that if there are big changes, we will socialize them and really consider them. As an example, the limitation to only a number of claims, right?
Right.
We kind of floated that, took some input on that, and we'll take that back for consideration. There are some changes that I can't take credit for, but I was there to witness, like the new portal, which I think is just a terrific change. Anything that makes it easier to use the process makes the process better. A little bit later this year, we're going to be turning our attention to the online archive and to improving the quality of that experience as well. And so those are, going to be handled with our amazing tech folks. But we all have a hand in it because we hear some of the critique, and we've been utilizing that system for a very, very long time. So nothing big to announce today, Len.
Today, okay.
And then one of the
It's only
things,
been 2 months.
yeah, exactly. I know. And one of the things too is when there are changes, like you said, you socialize them. So that's one of the things where the attorneys and other participants have the ability. It's not as though you have like a suggestion box email, but you do have regular meetings. We have the upcoming NAD meeting in September, and those and so you do listen to what participants are telling you.
And actually we have some interim opportunities for feedback. Law firms and companies that are national partners can be on committees of the organization. We have an upcoming national advertising committee meeting. And so in between our annual conference, we've got some touch points with the people that participate.
So you have an opportunity. So for people who are asking questions, because we always get this, people say, oh, well, can we do this? Can we do that? And I think that the NAD generally, I think, is very open, and they listen to suggestions, and they tell us why. They say, okay, well, this suggestion doesn't necessarily work because of this reason, but this we could talk about, and we socialize it, and then maybe like SWIFT. I'm sure SWIFT took a little while to get into place, but it eventually did come into place, and I think it's worked out tremendously well.
Yeah. And I would say I'm open to receiving suggestions.
Sure.
I can't say necessarily that they'll be implemented or that, the floodgates should open now, but I do have an open door policy, and I'm open to listening.
Right. So who makes the decision on changes ultimately? Is it you, or is it you with folks at national programs?
So it depends on what kind of change. I don't think we could implement a brand new track on our
Sure.
own. We are part of a larger organization, and there are financial implications. And if you pull a string over here, it might have an effect
Sure.
over there. So we operate as a whole, as an organization. Smaller things, like we're taking a look at the procedures again, just to make sure that things that may have fallen through the cracks or need to be clarified, we might bring those up to date, and those can be done within our group a little more readily than bigger initiatives.
Sure. Okay, that makes sense.
So we had talked a little bit about the relationship between the NAD and the Federal Trade Commission earlier. Len and I just talked about the deregulation nation of the FTC on another webinar, and everyone thinks, okay, the FTC, everybody's doing nothing anymore. The whole, but the question I wanted to ask you is, NAD, it's always stepped in and helped the FTC out, right? Because the FTC has always had limited resources, and so in many ways, you've done a lot of their job for them. But now, do you think that the relationship between the FTC or NAD is gonna change at all, or do you think it's business as usual? What are your thoughts on that?
It's a bit more complicated question than that, and I might rephrase the relationship between the FTC and BBB national programs a little bit differently. I'm not sure we've done their job for them, but what we used to say at the Federal Trade Commission was more cops on the beat, is better, right? And a self-regulatory program like what you described, Len, when you were talking about our history, there was a need for it, and there is a continued need for it. So whether or not the FTC's priorities shift a little bit, we have seen an ever increasing number of challenges filed before the NAD. And as you said, we've got our monitoring priorities as well. I don't see a slowing down. It's maybe a little too soon to say whether we're going to see the floodgates open and people who want their issues resolved somewhere will come to the NAD because they think they're not finding redress or attention elsewhere. I don't expect our relationship with the Federal Trade Commission to change. And as a legal standards matter, we don't set the standards, we apply the standards. And so we are taking the law and the guidance as it is provided by the Federal Trade Commission and applying it in the context of our cases. Now, a lot of the cases that the NAD reviews are of a slightly different nature than what would be brought by the FTC as an enforcement case in any event. I mean, the telecom cases are good examples. You know, number one top performing claims. The superiority claims, you know, the Federal Trade Commission has tended not to take action in those areas at all. But competitors really care about cleaning up, you know, their own relevant marketplaces. In other instances, there is a lot of overlap in influencer marketing, at least in the past. We have kind of been a co-announcer of decisions with the FTC. One area that people are suspecting will be active both at the FTC and at the NAD in the coming year, at least, will be cases involving Made in USA claims. Those are kind of at the forefront of a lot of marketers' minds right now. The FTC is going to prioritize them and has, and I think we're going to see some challenges before us in that area too.
I mean, one of the things I think that accounts for the growth in your docket is these comparative claims. It is so expensive to go to federal court and open the gates on discovery, and especially electronic discovery, and you know, tens of thousands or hundreds of thousands of documents and then depositions. You know, you can avoid that at NAD, and I think that's one of the things that makes...
You can avoid it, especially if the remedy you want is for the advertising to change.
Right. Yeah. I mean, obviously you can't award damages, but you can give the equivalent of an injunction. I mean,
and faster.
Yeah, much faster and much cheaper. So I think because I don't see the cost of litigation coming down anytime soon, I think that's going to continue to be a real motor of your growth.
Yeah.
And I think that's a good point. One thing that we're seeing when we're litigating these cases in court, in federal and state courts, is that judges, and people have heard me say this, so I apologize if you heard me say this before, judges are becoming, I mean, they're younger. They're less experienced. Like, it's really, really jarring for me to go to court and be in front of a judge who's younger than I am. I'm not saying I'm young, but I'm not that old. I'm like, do you know what I mean? And so they're a lot less experienced than they might have been in the past. And we're seeing very variable decisions in areas where you would think you would see a certainty. So I'll give example. Environmental advertising claims. So there was a case that came out in favor of a company based on things like whether or not damages and causation was pled when there was an environmental claim about, you know, aspirational for carbon neutral. And then we have other courts coming out different ways on aspirational claims. And you have the New York AG with the JDS case. And what I think is really important to think about when you're looking at the NAD is that is something that is highly unlikely to happen at NAD as opposed to going to federal or state court, because you are really rolling the dice in addition to the money that you're going to spend. You know, even going to the same jurisdiction, if it's California, two judges in CD Cal might come out different ways on the same facts. And that's something that I've always told people NAD is very consistent. I think
Predictable.
Predictable, exactly. Yeah. That's exactly right. Predictable. Now more than ever, I think that predictable nature of it is incredibly important. So we've gotten a lot of questions. So I've been asking people for questions throughout, and I want to make sure I ask some of these. The NAD monitoring priorities. I want to talk to you a little bit
Yeah.
about what your monitoring priorities are going to be, and then I'm going to follow up. I'm just going to give you a heads up. I'm going to talk a lot about influencer marketing because everybody is asking about that. So why don't we start, Phyllis, with what do you think, to the extent you can tell us, are going to be some of the monitoring priorities that NAD, when NAD brings a case on its own volition, what are you thinking about are going to be on the top of that list?
So this is an area where I can help set the priorities. So I'll talk a little bit about what have been the priorities kind of leading up to my time joining the organization and what I see going forward. So we had a slew of influencer cases that we issued over the past couple of months that were monitoring cases, and they involved pretty high profile celebrities and those celebrities' ties with brands that were not disclosed. And so, I think we're going to continue to see cases in the influencer area as long as there are cases in the influencer area. I mean, this is an area that, depending on who you ask, some people say, everybody knows at this point. But I think the facts aren't bearing that out, that we are continuing to see each new flavor, a slightly different iteration of a brand relationship, and triggering an obligation to disclose and an absence of those disclosures. We developed a priority in the area of AI, and we have an attorney at the NAD who is primarily focused on bringing AI cases. We came out with one just at the beginning of this week, actually, against Microsoft. And prior to that, we had a case involving Google and one involving Apple. We've got one or two more in the works there. AI will continue to be a priority. We are looking at AI and baby tech next as one of our areas. That kind of moves us into the area of kids and teens. You saw a monitoring case a couple of months ago. It was our first overlapping case with our sister division, KRU, which is the Children's Advertising Review Unit, involving the marketing of cosmetic products to very young children. And I think we're going to continue to see some inquiry and enforcement in that area. And cosmetics more generally is an area of focus for us.
That's really interesting, and that's very, very helpful, Len. I think that's timely because we just had some meetings with some cosmetic companies. I want to talk to you about influencers in particular. We did see a slew of those influencer cases, and I think that was really helpful because I suggest everybody look at those because those really set the standard. And for those who aren't familiar, there have been now class actions.
Right. This is a new development.
This is a new development. So class actions have begun being filed involving influencer marketing. I'm not sure if NAD was the impetus for that or if that's just the impetus. There's so much influencer marketing.
I mean, I would hope that the NAD was not the impetus for that. But, influencer marketing, it's not new any longer. I was involved at the FTC in bringing the first influencer case against Lord and Taylor. That was 10 or 11 years ago now. And it was really back in the day because at the time, I could not believe that there was a sector where you got paid to post pictures. It took me a while to get my head around it. So we are, a decade into this burgeoning and very lucrative field. And we have continued to see cases in this area. So I don't know what is exactly spurring the class action. Maybe it's a revolution, maybe it's just a little flurry, but the cases have been filed against some big apparel brands for failure to disclose. We'll see what happens there, but the allegation is that harm was wrought, and presumably monetary harm, for the failure to disclose the influencer's relationship to the brand.
And I can imagine there'll be different legal theories. I know, Len, with that one case we were talking about
price premium.
How do you certify a class? How do you show if there's no code or click through like an affiliate link? How do you certify a class and show that there was injury there? But I wanted to ask you something that we were asked recently, which is a lot of our clients are saying, well, we have all of these influencers and we don't know who to work with. Like, we don't know who is legit. We don't know who's going to follow the rules. We don't know who's going to go behind our back and just go rogue and do things. Like, we wish that there was some sort of like accreditation and training program or some sort of program like that, so that we know, like, there's some sort of, I don't know, legitimacy, or at least something that helps us make a decision on maybe these people, maybe not these people. What are, I remember there were rumblings like a year ago or so that NAD was thinking about some sort of program where it might just be training. You could have an influencer that would undergo training or something else like that. Is that something that you're thinking about?
Well, watch this space. It is something we're thinking about very seriously. It's something we'd like to build, and we're going to be discussing more publicly in the coming months. And we'd like to see that real demand. I mean, if it exists, we are ready to be the overseers of monitoring and training and certification program.
That would be fantastic. I think that's something that a lot of companies are really, really interested in.
And in some jurisdictions, and we've taken a very close look at other marketplaces, these types of programs exist, and the brands in some of these countries require influencers who work with them to have gone through the certification program.
Yeah, and I think that's going to be an excellent, if we're able to do that, that will help a lot of companies, because I also think that we've got the endorsement guides right now, but the standards, we've had people asking questions about, influencers. It's very difficult when you work with influencers, because they, sometimes you can't even get in touch with them. You write them a message on Instagram and like they won't respond, and you're trying to work through their agents and things like that. So having some sort of training program and knowing that you're working with somebody who's at least undergone and taken those steps and made that investment is something that's going to be good. I want to ask, this is a little bit of a shift, since you are the new, head. Previously in the meetings, the in-person meetings, it would be either the challenger or the advertiser, the NAD staff attorney, and then the VP. Are you going to be attending the meetings going forward, or how do you envision, if at all, like the in-person meetings changing? Will there be any changes there?
So it's a slightly different format now, in that I'm not based in New York, and traditionally the entire NAD team has been based in New York, but we are growing, and a couple of us are in the Washington, D.C. area. And so COVID changed things for the worse for the country, but for the better for working environments, and that people became more used to virtual meetings. And so a good portion of our meetings remain virtual by the election of the parties, and those are easy for everybody to attend. Not all of our meetings are virtual. Some of them are in person, and I try to attend as many as I can, given my schedule. And so if I can't be in person, I have been virtual, and I can't be in every place at once, and so there have been some slight challenges to that, but my plan is to attend them. Now, if we grow and grow and grow, just by virtue of scaling a program, it may make less sense over time.
So I'm glad you said that, because I've been talking about this with a client, and they were really worried that if they weren't in person, they were, I think, on the West Coast, or it was very expensive to fly out, and they weren't a large company. They were really worried about not being in person and how that would look. So it's okay. Like
Completely okay.
So when we're talking to clients, it's okay to be virtual.
Yes.
It's not one of those things
Yes.
where you understand we're taking it seriously just because we're not flying out.
Correct. And
Okay.
we've had situations where some of us are in the room, some of us are virtual. The clients' attorneys may be in the room, but the experts are also virtual. I mean, we can all figure this out. It's not that hard.
There's no optics issues.
Right.
Then. So
that's
good.
No.
I hope we disabuse some people of that notion, because I know that was one of the questions that we did have. One of the other questions that we got this morning from another client was about regulated industries. So let's say FDA in particular. Again, we're in the world of deregulation. Do you see, or how do you see the NAD stepping in on some of the products that might be more regulated by, let's do FDA because that's an easy one, right? Like you've got pharmaceutical products. I know there were a couple GLP-1
Right.
cases. What are your thoughts? What can you tell us about those?
So we're not gonna, we're not interested in, able to, we will not usurp, jurisdiction. But there are cases, and there have been for a long time, where we have the ability to look at a portion of the advertising claims, even in the regulated sector. So the GLP-1 cases are a great example. We had a recent food case. I think involving tortilla chips and sodium content. There was a room cleaner case involving EPA approved claims. And so we are at our upcoming conference, and I know you're going to talk about that in a minute, but I want to just preface it. We're going to spend some time on a panel talking about our role in regulated industries, some of the challenges that are presented when particular claims have been approved, where our jurisdiction ends, and where we can go and what the effect are. So I would say come to the conference, because this is going to be a really interesting discussion.
I agree, and I know we're almost out of time, so I do want to give you a chance to make any closing remarks. But I do encourage everybody also to attend the conference. It's on September 16th and 17th. Is it New York?
It's in Washington.
Oh,
this
it's
year.
in Washington.
Yeah.
Hey, okay, so
Yeah,
I don't
yeah,
have to travel. But Len, you'll have to take the train
Good.
down there.
Yep.
So
Good,
it's on the
good.
16th and 17th, but you also mentioned there's going to be a pre-conference workshop on the 15th.
On the 15th, for people who have not filed a case before the NAD or haven't done so in a while, I want to learn more about the nuts and bolts, kind of following on from this webinar. We're going to have law firm associates doing a lot of the presenting, because they are the ones who do the initial drafting and the research. And we will have NAD attorneys sprinkled in the room, and lots of time for discussion and drinks at the end. And that will lead into our 2-day main stage conference on September 16th and 17th.
And I've had, again, I'm not falsely advertising, and it's an endorsement, but I've had clients say that this is the best advertise, that this is one of the best. This is one of the best.
If it's a truthful
I know,
claim, I love it.
It's somebody said that's very, and I recommend that people go, because it's a great way to get, first of all, CLEs, but also you learn really what's going on in the industry, the most standards.
Yeah, and not only that, we always have had people from the Federal Trade Commission presenting
Yes.
at our conference,
Yep.
and this year will be no different. And so the newest commissioner, Mark Metter, will be speaking in a keynote, and the new BCP director, Chris Mufarage, is also going to be speaking. So it's a way to hear from the enforcer in a somewhat of a rare opportunity.
So I know we're at the top of the hour. If you have any other remarks, if not, I can give everybody the CLE code one more time.
Oh, no, it's been a pleasure. Thank you guys for
Thank you.
hosting
This
me,
was great.
and thank you to everybody for listening in.
Thank you all. Again, that's NAD 2025, and the slides will be available afterwards. And if you have any questions, please feel free to reach out. Thank you again for attending, and have a great day.
Thank you all.